All right, we're moving now to Varanasi, a city that since yesterday has seen heavy security in anticipation of the Varanasi District Court's order on the Gyanvapi case. Now, the decision today relates to the maintainability of Hindu women's pleas. These were 5 women. They were seeking permission to worship Hindu deities that they claimed were inside the Gyanvapi Mosque complex. The Anjuman Intizamiya Masjid Committee has said that the Gyanvapi Mosque is a Waqf property. They question the maintainability of the plea. Now, the case is being heard by the district court following a Supreme Court order. The district judge will be rendering its decision on whether the ongoing trial in the court regarding the permission to worship is maintainable and whether the plea is based on tenable grounds. Now, I have 2 colleagues with me this morning to bring us a lot more context on this story. First, my colleague Pranshu Mishra with us live as we speak from Varanasi. After that, we'll be going over to Ananya for more legal perspective on the case. Pranshu, we were just telling our audiences about the heavy security in place across multiple districts in Varanasi. I believe there have also been flag marches. Could you bring us the mood right now on the ground?
Yes, that's right. In fact, it's a much awaited decision, and there is a strong possibility that once the decision comes out, the communities concerned might be, getting very emotional or reactive, and that's the reason why security arrangements have been put in place. Section 144 has already been declared all across the urban areas of the city to ensure that no celebrations takes place, no, victory processions comes out. But the matter of the fact, and this is also an attempt on the part of administration and those involved to try and make people understand that this is just one, moment, one chapter of possibly a long-drawn legal battle. Now, the fact here remains that today the court is, of course, going to rule out that whether that petition filed by the Hindu women, the devotees in this Mashingar Gauri versus the Gyanvapi case, whether the petition filed by the Hindu side is maintainable or not. Even if the court, says that it's a maintainable petition, then of course we know that this case was primarily in Supreme Court, where Supreme Court has actually transferred this petition to the District Judge Court. So there would be a lot of possibilities for either side, the Hindu side or the Muslim side, to react to this judgment, approach and appeal against this judgment in the concerned court if this judgment is not in their favor. So the point is that today it's just prima facie one thing, that whether the petition that was filed initially by the 5 Hindu women devotees in the Court of Civil Judge Senior Division, on the basis of which the Advocates Commissioner-led investigation was ordered, and then subsequently the Wazu Khana area was sealed, whether that petition in its basic form, whether it was maintainable or not. So this is what the court is going to decide today, and of course because of that, today is a big day and security arrangements have been tightened up across Varanasi city.
Pranshu, stay with us for just a second. Ananya, stay with us too. Very quickly, I just want to walk our audiences now through different conversations related to this story. We're going to take you through what lawyers, for example, have had to say, what the petitioners have had to say. Take a look, then we'll go back and connect with both of our reporters on the ground.
The court said that the matter is very complex in nature, but what emerged out was that the Muslim side, the Jamiyat-e-Ulema-Hind, was actually in support of the judicial review not being there. So how do you see the stand of the Jamiyat-e-Ulema-Hind coming?
Ananya, I'm so grateful that you have asked me that question, because kindly see the dichotomy. On the one hand of this entire setup, the same government, Narasimha Rao government, enacted the Place of Worship Act and the Waqf Act 1995. Under Waqf Act 1995, Section 40, Subclause 3 has the provision to declare any property as Waqf property, including the property of trust and society. Against that, an appeal is provided to the Waqf Tribunal, then to the High Court, then to the Supreme Court. And for us to reclaim back our temples, the right of judicial review is also taken away. So you have made the majority community as second-grade citizens in this country, and this is the sheer appeasement politics which has played, because of which this Places of Worship Act was enacted. And on this very footing, these provisions have been challenged before the Supreme Court, and I am hopeful that one day will come when the Places of Worship Act Section 4 Subclause 2 will be declared unconstitutional by the Honorable Supreme Court.
कोई षड्यंत्र या किसी तरह का कोई भी अफवाह पर ध्यान न दें और न इन अफवाहों पर जाने की प्रयास करें। पहले सच्चाई को मालूम करें, उसके बाद तब कोई आप निर्णय लें और जोश में ना आए। मेरी यही अपील होगी कि जोश में ना आए, क्योंकि जोश में कुछ नहीं होना है। हमारा और आपका दोनों का नुकसान होगा, कारोबारी नुकसान होगा, हर तरह से नुकसान होगा, जानी माली भी नुकसान होगा। तो इससे बेहतर है कि हम कानून में जब अदालत में आए हैं तो अदालत जो फैसला करेगी उसको माना जाएगा।
Okay, my colleague Ananya is with us right now to bring us more context on this case. Ananya is going to bring us the legal perspective here. Ananya, this is a case that we know has gone, it's been looked at by the Varanasi court, then by the Supreme Court, now today again by the Varanasi court. Bring our audiences first a quick timeline of what the last few months have looked like. Tell us about what we could possibly expect today. And then, Ananya, tell us about the implications. Because immediately in the weeks following the Gyanvapi case and the hearing around the Gyanvapi case, we heard of similar such cases crop up in multiple cities across the country. So tell us a little bit more about the possible implications.
Well, first, Toya, I'll take you through the timeline of this case. A case was filed before the senior civil judge in Varanasi. It was a civil suit by 5 Hindu women seeking, in fact, prayer rights at the Gyanvapi Mosque, saying that there was a temple on which this whole mosque has been made after raising those temple structures. And in fact, we also saw when a survey was conducted here, a shivling kind of structure was recovered. However, we'll have to wait and watch as to what the court has to say on this. But what is very, very crucial today is that the court is all set to pronounce its order on the Order 7 Rule 11 application that has been filed by the Muslim side. Now, what Order 7 Rule 11 essentially means is that if at all a suit has been filed before a court, then the relief that has been sought, if they are not permissible under the law, if the law does not permit a relief to be granted in those particular provisions of the law, then the suit has to be dismissed. And this is what is in fact the premise of the Muslim side's argument. However, the Hindu side constantly goes on to argue that the Section 3 of this particular act gives a judicial review power to any of the side, and in fact it also says that the religious character of any of the place of worship can be redetermined. However, the Muslim side contradicts that and has already filed as Order 7 Rule 11. Now, today the court will rule on the Order 7 Rule 11. If at all this application is accepted, then the Hindu side suit would completely fall flat to the ground. The Advocate Commissioner's survey, the whole exercise that has been conducted at one point of a time where the videography of the whole premise was done, would fall flat. However, if this petition is dismissed today by the Varanasi court, then definitely the Hindu suit would sustain, and in fact furtherance can be obtained. Now the suit can be argued on. So today it is only about the maintainability of this particular suit, but it would be a very, very crucial order from the Varanasi court today as we hear it. And remember that when the Supreme Court had heard this particular matter, the Muslim side had constantly argued that the Places of Worship Act does not permit for a devising of a religious characteristic of a particular place of worship, while the Hindu side was clearly claiming that Section 3 permits this. And in fact, Justice Chandrachud had also orally observed that in fact Section 3 does not have a bar, that a religious structures, religious character cannot be redetermined. So it had then sent the case to a senior civil judge there. In fact, the district civil judge, because remember that if at all this suit, any kind of an order is passed by this particular court, then it would go to the Allahabad High Court as a legal remedy, or it would directly go before the topmost court of the country, that is the Supreme Court. And essentially, that is the reason why Supreme Court had also given out an interim protection at this particular time when it had sent the case to the senior civil judge, saying that its interim orders would continue 8 weeks after these orders are passed, so that any of the parties who are aggrieved by this particular order can approach a higher forum, can approach another court to in fact sustain their legal remedies and to exercise them. It had given a sufficient amount of time to all of the parties in case there is some kind of adverse order to some of the party, whether if at all this suit is the Order 7 Rule 11 application is dismissed, then the Muslim side would definitely be approaching the Allahabad High Court or the Supreme Court. And if it is allowed, then the Hindu side might be approaching the Allahabad High Court or the Supreme Court. So we'll have to wait and watch. A very, very crucial order. Security has been tight, as Pranshu was pointing out, so that no kind of a reaction takes place, no kind of a uncertainty comes up. So we'll have to wait and watch.
Ananya, stay with us.